The Honourable Shane Jones.
Kia ora no tātou. Sir, as befits the speakers on this side of the House, devoid of any extravagant claims or vanity, we say with some modesty that this bill is the work of both sides of the House, and it happens at a time when there's a lot of unfinished business in the Leaky Homes area. Some of the most celebrated pieces of litigation, sir, flowing from the Leaky Homes drama pertain to the occupants who live within property covered by unit title. There have been large bouts of litigation all the way to the High Court. There have been cases where people with corporate management responsibilities have not been either objective or respectful of the rights of minority interests, and indeed, in addition to that, there have been minority interests who have tried to hold to ransom the majority of the people as they've sought, sir, to correct the building defects which leaves them living in aquariums. And it's important, sir, in this context that we provide that kind of background to this bill. This bill did seek to upgrade the legal infrastructure around this type of property right, but it was given a larger sense of urgency because of the very cruel developments that have happened to people once they've occupied these properties and found that they haven't been professionally made, or the materials that were provided by the manufacturers, who have largely got off scot-free, have not stood the test of time. So the important thing about this bill is that it actually improves the legal articulation of what is the extent of the property rights that individual owners have within these complexes, and what are the obligations and duties on the corporate managers. Levels of disclosure have been improved. There's a myriad of stories as to how people have found it impossible to establish whether or not the fees that they've paid are being dedicated towards maintaining the key capital components of the complex. And whilst I was the Minister for a short time, we've got no end of tales of woe in that regard. But so in areas such as, let me focus on Auckland, Tamaki Makaurau, super city considerations aside, there is an ongoing challenge as to how do we in Auckland enlarge the supply of residential housing stock. There is essentially a statutory, through the planning regime, ring around Auckland, making it exceedingly difficult for residential property development to take place. And it's always seemed to me, sir, that when we were working on this bill, that with an improved set of duties, obligations and rights, and an enhanced infrastructure dealing with these types of complexes, it may improve the prospects of us seeing an enlarged supply of residential units that go up and not necessarily out. Because, sir, that is a major problem, in my view, to the affordability of property in our largest city. And whilst that, no doubt, the current Minister would agree, was not the primary focus, as people's confidence grows, as investors and occupants of these properties, as their confidence grows, sir, to live in these types of complexes, then capital and developers, I'm sure, will be attracted to providing that as a housing option. Because what the situation is in relation to Auckland housing at the moment, it's essentially unsustainable. We've got a geometric level of growth in terms of domestic migration, people going to Auckland, not coming to the winterless north or the deep south. A few get lost there in the verdant pastures of Waikato and Matamata and surrounded by racehorses and other such things. But the deeper problem, sir, is for the families, either international migrants or domestic immigration coming in. And I think that we ought not overlook that. In respect of transparency and the quality of information and the quantity of information made available, this actually empowers owners. and it clearly provides a process where they have a complaints avenue and they're able to hold accountable the actual statutory agents who have not only a fiduciary responsibility, but now they have an actual legal obligation. And sir, that level of disclosure is something that in a sense was debated in the bill that has just passed us by in respect of financial literacy, financial stewardship, etc. And when people feel that their access to information is blocked, which has been the case in many of these complexes, and they don't know where to turn, the first thing they do is they inherit or they end up incurring unnecessarily large amounts of legal cost. And actually lawyers from all across the spectrum did say to us, of course they'll never agree, but that's the nature of the law, it's an adversarial beast, they did all point to us that, well, there are a few exceptions, and the current Attorney General is seeking to find common ground, but an injudicious answer that he made last week to a very sensible question begun to cause doubts to sprout in our minds. However, we'll overlook that small lapse of standards by the Attorney General, etc. But anyway, I want to come back to the quality of information. Where the information disclosure regime contained in this bill is maintained, it'll enhance confidence, and people will not be required to incur unnecessarily large bills, and they'll be empowered, because this is actually a transition away from the average garden variety Kiwi experience, those fortunate enough to own a home on something akin to a quarter-acre section. Here you have shared space and you have a shared obligation to maintain the key features of the complex, and you trust those agents who are the corporate managers. Now, some of them, sir, may actually be associated with the original developers, and they may set up an adjunct company to maintain an ongoing role, if indeed they haven't been able to sell all the units that they develop, and a managerial role. Now, that in itself, sir, I was told, actually caused doubt and disquiet, because it took them a long time to correct small issues, whether it was lift wells, whether it was parking, or the general deterioration of the complex. So let us not overlook the power and the disinfectant-like quality of disclosure and very good information. And sir, unfortunately there will be conflict. As I said earlier, lawyers are involved, and the jurisdiction of the tenancy tribunal, that is made a lot more lucid. And unfortunately, sir, we're going to see many of these disputes, it would appear, if the managers continue on with their shoddy practices of not being responsive to people who are often in their twilight years, living in these complexes, etc., unless they're responsive to the queries, anxieties, because often this is a key asset that they have after a lifetime of work and scrabbling around and maintaining a small nest egg that hasn't been consumed by Mr. Bryers and others. And these avenues, sir, are going to be very important. So the key point I'd like to leave us with is that we enjoyed contributing to this bill. It's a prolix, complex area of law, but it actually gives a greater level of clarity to duties and rights in law for this type of property, and it'll expand the opportunities for people to hopefully enlarge the supply of housing in our key metropolitan area, Auckland, and I support the bill. Kia ora tātou.